Welcome back to another discussion on registered land and registered estates in land. And in this video, we're going to be talking about the Land Registration Act 2002 Schedule 3. But before I get into this, I'm going to do a quick recap of what I've covered in the previous video or videos, just so that I can bring you all up to date or just give you a quick overview of what we've looked at so far. Just in case you've been a bit confused, you can just sort of see get a more holistic understanding of the topics. If you're quite happy with what you've watched so far, just skip straight ahead until we get into the meat of Schedule 3 in a few minutes' time. Okay, so a quick recap. So estates in land, estates and rights in rem under the Land Registration Act 2002. So all legal freeholds and legal leaseholds of more than 7 years can be registered on the land register in their own right under unique title numbers. Most rights in rem can be noted on the charges register of the estate they burden. The main exceptions are the beneficial interest under trust and short leasehold. So you can protect your rights in rem by putting them on the charges register in the land register, and there are a couple of exceptions which we also discussed before. But what are the effects of rights in rem on disponee? So if you have protected that right in rem on the charges register, what effect would that have on a disponee? So the Land Registration Act 2002 contains rules establishing whether a pre-existing right in rem burdening a registered estate takes priority over a new right in rem burdening the estate, new freeholder ownership of the estate. So the question is whether or not, if you have a right in rem over someone's land and then that land is sold on, will that right in rem bind that new land owner? And these rules are contained in the Land Registration Act 2002 section 29, and the rule in section 29 is engaged where there has been a registrable disposition of a registered estate, that's the Land Registration Act 2002 section 27, for valuable consideration, and the right in rem granted transferred by the disposition has been registered on the land register. So section 29 establishes that pre-existing rights in rem will take priority over the new right in rem if the pre-existing right in rem has been registered on the land register, or the pre-existing right in rem falls within any of the paragraphs of Schedule 3. Okay, so in the previous video, we looked at how a pre-existing right in rem would take priority over a new right in rem once it has been registered on the land register. That was really the focus of the previous video. So the focus of this video is in the second part of when a pre-existing right in rem will take priority, and that's if it falls within any of the paragraphs of Schedule 3. So we're going to break down Schedule 3 now and have a look at how it works. Okay, so here's the second section of this video on Schedule 3 of the Land Registration Act. So unregistered interests which override registered dispositions. Okay, so Schedule 3 lists 9 rights in rem which take priority over a newly granted transferred right in rem. It says in relation to these rights in rem can take priority under section 29 over the newly granted transferred rights in rem in question. So we saw that one way in which a pre-existing right in rem can take priority if it is registered, which is the first route that we looked at in the previous video, but the second route is here under Schedule 3. So if your right falls under Schedule 3, then that is great. You satisfy section 29 and your right will take priority over the new interest, whether that be a freehold, mortgage or a lease, etc. So the pre-existing interest will take priority over it, so it binds it if it falls under Schedule 3. So priority is achieved by the rights listed in Schedule 3 despite the fact that they are unregistered. In other words, they are not noted on the charges register of the estate in which they burden. So our focus out of the 9 rights is the rights under paragraph 1, 2 and 3. So the beginning of the schedule is what we need to focus on. So Schedule 3, paragraph 1. A leasehold estate in land granted for a term not exceeding 7 years from the date of the grant, except for a lease for the grant of which falls within Schedule 4(1) D, E or F, at least the grant of which constitutes a registrable disposition. So the first thing to note is that the paragraph is concerned purely with legal leases as they are, quote, granted, okay? Remember, the formality requirements for leases is slightly more complicated. So leases of 7 years or more have to be registered in order to be legal. That's the Land Registration Act 2002, Section 27. But Section 27 does not deal with leases under 7 years. So this means that a lease for fewer than 7 years is allowed to achieve legal status even if unregistered, provided of course there is a deed, unless it is a lease for under 3 years, which can be created orally under the Law of Property Act. So it deals with legal leases and allows such interests to override a registrable disposition under Section 29 despite their non-registration. So this should be pretty straightforward. I don't think I need to go into much more depth than that about Schedule 3 paragraph 1, but just know that there are these different ways that a legal lease can come into effect and bind disponees. Schedule 3 paragraph 3. We'll go back to Schedule 3 paragraph 2 in a minute, because that's a little bit more meaty. In fact, I might even leave that for another video. In fact, I will, I think, because it is a difficult topic. Well, not difficult, but it's just a bit more to it than just a quick brief discussion. I need to get into the actual meat of it a little bit more. But Schedule 3 paragraph 3 says that a legal easement, except for an easement, which at the time of the disposition is not within the actual knowledge of the person to whom the disposition is made, and B, would not have been obvious on a reasonably careful inspection of the land over which the easement or profit is exercisable. The exception in subparagraph 1 does not apply if the person entitled to the easement or profit proves that it has been exercised in the period of 1 year ending with the day of the disposition. So, like I said in numerous videos about the law, this is not worded very well, and it takes some time to work out what right is actually protected under this paragraph. Now, it is a legal easement which either the disponee knows about or was objectively obvious or has been exercised in the last year. So this is the right way to formulate this. If you try and work through it, it will get confusing. So again, a legal easement will fall under this paragraph if the disponee knows about it. For example, imagine if the disponee in question is someone who purchases the freehold estate, and if that purchaser of the freehold estate knows about a previous legal easement over the freehold that they have purchased, then the easement will fall under this paragraph. If it was objectively obvious, so that will be on an inspection of the land, and if it is neither of the other two but has been exercised within the last year, it would also fall under this paragraph. So there are 3 ways in which your legal easement can fall under paragraph 3 of Schedule 3. If any of those are satisfied, then you have a legal easement under paragraph 3. Therefore, the priority of that legal easement is going to be protected for the purposes of Section 29. But why do we need this channel of protection when legal easements are necessarily protected by deed? The point to note here is that Section 27 is restrictively the express grant of an easement. So the express grant of an easement needs to be registered in order for that easement to achieve legal status. So this paragraph actually deals with implied legal easements that won't have been registered. And I'm going to talk more about implied legal easements when we talk about easements in a separate video. So this, again, like many aspects of the law, will make more sense when you go back round to it after you looked at easements in more depth. But just note that there's 3 specific ways here in which a legal easement can fall under paragraph 3, and it's specifically about implied legal easements. Okay. Now, in the next video, I'm going to look at Schedule 3, Paragraph 2 to really finish off what our understanding is of Schedule 3 here. So I would recommend you go check out that video right now. If you have any questions about this video, please leave a comment below and I'll get straight back to you. And make sure you subscribe to my channel so you don't miss the next video. Thank you very much.